Wisconsin Supreme Court Justice Daniel Kelly was appointed to the bench in 2016. He's running for a full term in the April 7th spring election. Because there are 3 candidates, there will be a primary on February 17th. Justice Kelly, welcome to WisconsinEye.
Thank you so much. It's great to be here.
You were a shareholder, a partner in a major law firm in 2016 when Justice Prosser resigned. Why did you apply to join the court?
So I actually, right before I applied, I had started a firm with a friend, and I'd spent most of my career, however, in a major Wisconsin law firm as a shareholder. Mm-hmm. So the reason I applied was, I think, a lot of the same reasons that drove me to the law in the first place. I've been in love with the law since I was in 7th grade. I always had wanted to be an attorney, and I always wanted to be a litigator. And the reason for that, and I think I got a lot of this from my folks, they impressed on me the importance of justice. They impressed on me the importance of following rules. You know, it started with following their rules, but you know, as you grow and you mature, you find out, you know, that's important as you become an adult and throughout society. And it's extraordinarily important that people have their rights protected, and that's why I wanted to be an attorney, is to make sure that we were protecting rights. So as I considered the opportunity to be for service on the Supreme Court, there's a lot of the same kinds of considerations that went into that. I looked at our court and the important role that it plays, mm-hmm. and a lot of that role is ensuring that the rule of law is followed by everyone. And by everyone, I mean, you know, not just those of us in community, but those of us in office, that people in government follow the rule of law as well. And that's the key to our form of justice, right? Everyone is answerable to the law. And because of the importance of that kind of concept that goes into preserving our freedoms and our liberties, the opportunity to serve in that kind of capacity was just very compelling.
We've had a couple interesting races in 2018 and 2019. What's at stake in this election, sir?
I think the direction of the court. So part of the reason that I'm running, and one of the reasons that I talk with the folks of Wisconsin about why I would like to serve for another 10 years, mm-hmm. is because of my judicial philosophy. And I think that's what's at stake. So for me, service on the court is all about the rule of law. It's about staying within our proper boundary, staying within our proper lane. And that, the short explanation of that is, we don't make the law, we don't ignore the law, we don't play favorites with the law. We just apply the law as it exists, not as we might wish it to be, but as it's actually written and maintained by the people of Wisconsin and their legislators. And there's a much longer answer that goes into that, and an explanation for why it's so important that we restrict ourselves to the lane that the people of Wisconsin have set for us, just exercising the judicial power, just using the law to decide the cases and nothing else, setting aside our personal beliefs and preferences in politics and not let that come into the equation of the work that we do on the court.
Do you think in previous decades that Wisconsin Supreme Court had a history of activism?
It has. It's been episodic. And you know, it ebbs and it flows, but there have been periods where the court has abandoned its role as the protector of the Constitution and having the responsibility of simply applying the law as it exists. And there are several cases that are demonstrative of that. But there have definitely been times when the court has gone in that direction that I think is inappropriate.
Do you want to cite the case that you consider most egregious?
Yeah. So there was one, the Ferdinand case. There, the legislature had set a cap on non-economic damages and medical malpractice actions, and the court struck it down. They said it was unconstitutional. But if you take a look at the opinion, it's really difficult to find anything in there that suggests that such a thing is unconstitutional. The cap got reenacted in a slightly different form, mm-hmm. came back to the court, mm-hmm. and we took a look at that again just a few years ago, and we saw no constitutional infirmity with it. So, you know, this is about, and whether the cap on economic damages is good or bad policy, that's not for us to decide. is simply for us to decide, did the legislature have the authority to enact the law?
You've heard the criticism that because you haven't been a circuit court or court of appeals judge, you are at a disadvantage joining the court. What's your response to that, sir?
Yeah, I don't see any disadvantage in that. Part of my practice, in the focus of my practice, was appellate advocacy. So there's actually a much smaller step between being on this side of the bench and the other. So I had a deep and broad experience in arguing appellate cases, not just here in Wisconsin, but across the country. And so when the opportunity came to apply for the Supreme Court, making that transition was actually a lot shorter than others perhaps have had. So if you don't have appellate experience, that leap is actually going to be much larger than mine. So if you serve as a trial court judge but you've never done appellate advocacy, that's going to be a much bigger step than I had. If you've never practiced law in Wisconsin, of course, that's a huge step that I didn't have to take.
You've been writing opinions for 3 terms. What one opinion are you most proud of that's most significant?
I'd have to say that would be the Tetra Tech case. We dealt with a very significant issue of separation of powers between the different branches of government. And that's, my insistence on following the law comes from the understanding of the foundational role of our Constitution. And we've got to make sure that we are staying within our proper boundaries, and we need to make sure that the others are as well. And in that case, we had an opportunity to look at a doctrine that had grown up actually inside the courts that had the effect of taking some of our authority and moving it over to the executive branch. And so we looked deeply into that question and found that we had, in fact, allowed some of our authority to migrate to another branch of government where it didn't belong. And so in that case, we brought that authority back to the courts where it belongs.
Collegiality has been an issue on the Wisconsin Supreme Court. How is the court doing now, working together, and how are you contributing to that collegiality, Your Honor?
Well, I think they're doing great. So when I came to the court in 16, I'd heard a lot of the stories that you had and the rest of the people of Wisconsin had heard about this lack of collegiality. But when I got there, I think they were really well on their way to healing. And so what I found was really not what I expected. What I found was a court that was largely doing well in working together with each other. And I think that's improved over time.
It has.
So, my contribution to that has been, it's how I have approached working with colleagues pretty much my entire career. And that's 3 things. You walk humbly, you love unconditionally, and you speak the soft word that turns away wrath. And I think if you can do that, then you can work peacefully and prosperously with your colleagues.
I hear echoes of Micah, do justice, love mercy, walk humbly, but we won't debate the book of Micah here. News stories refer to you as one of the court's a member of the court's conservative majority. Is that a fair description?
Well, it all depends on what you mean by conservative. So here's the thing. We have a tendency to use the same labels when we talk about jurists that we do when we talk about politicians. But the labels mean different things in the different contexts, right? So liberal versus conservative in a policy-making context is just a completely separate thing from when we talk about the juridical context. Yeah. So the term that I prefer to use to describe myself is a constitutional textualist. And what that means is that I do what I can to be faithful to the text of the Constitution as is actually written and as it has been maintained by the people of Wisconsin. And when we're talking about the United States Constitution, by the people of America. So when we look at that text, what we're trying to figure out is what was the original public understanding of that language at the time that it was adopted. Right. And then we use that to decide the case in front of us. As opposed to looking for new and novel interpretations of the language, perhaps the way it might be understood today rather than when it was adopted.
Well, that's a pretty interesting debate because our constitutions were written obviously 200 plus years ago, and you've heard the school of thought that the complexity of our society right now requires some interpretations, but you sound like a strict constructionist.
Well, what I would say is that, opposed to strict constructionalist, I say I'm faithful to the text. Now, that's not to say that the Constitution doesn't need to be updated from time to time. You're right. It was written a long time ago. It was written at a time that couldn't anticipate all the circumstances that we face today. However, the Constitution has in itself the way to update it, right? It has an amendment process. The United States Constitution has that. The Wisconsin Constitution has that. So the question is not whether or not the Constitution needs to be updated from time to time. The question is who gets to do that? And the Constitution says that's left to the people to whom it belongs to update it. It doesn't say that we, the justices, get to do that. And so, and I take that very seriously because I understand that all the authority that I exercise is on loan from the people of Wisconsin. And I can only do what they've asked me to do. And so when it comes to a question like that, which is a great question, when the Constitution needs to be updated, I look to see who they've asked to do that. And they've reserved that authority to themselves. And we need to respect that.
The Republican Party has endorsed in working for you. The Democratic Party has endorsed in working for Dane County Judge Karofsky. Is this, but you're running for a nonpartisan race.
Indeed.
Are these partisan sides healthy for what is supposed to be a nonpartisan race?
Justice? Well, I think if the parties want to be involved in the conversation about who should be sitting on the bench, I think that's fine as long as we make sure that we're having the right kind of conversation. Right. So if we're talking about the role of the court rather than what policies are beneficial to the state of Wisconsin, then I think that's fine. The parties typically deal with with the legislators and the governor's offices. In that context, they talk about what good policy will contribute to human flourishing, and that's their role, and that's great. If they want to talk about the judicial race, that's fine too, as long as they're talking about a judicial race, right? So if they want to come in and say, look, we want justices who are going to be faithful to the Constitution, who are going to leave the policy making to the legislators, I think that's just fine.
What about third-party groups that can accurately or not so accurately describe your positions or your opponent's position? Do you welcome the roles, the potential ads from third-party groups?
Well, I'd say that I welcome anyone who wishes to exercise their First Amendment rights to participate. This is one of the key aspects of living in a free society like this. It doesn't depend on me and what I personally wish for people to do. I'm here as a servant to serve my 6 million bosses in the state of Wisconsin. And if they want to bring folks in to talk about this, that's up to them. That's for them to decide. And I think that what we have to do is respect their right to do that.
Your social media post in June 2019 just intrigues me. You were at a firing range. Were you firing an AK-47?
That was an AR-15.
An AR-15?
Yes.
Is that your AR-15?
It was not. That was that belonged to the gun range.
But you have made no secret of your support for Second Amendment, the Second Amendment of the Constitution. Did you see that as under siege?
Well, I think I've made no secret of my support for every constitutional provision, and I don't privilege one over the others. Right. So again, my responsibility is to the entirety of the Constitution, because that's what the people of Wisconsin have asked me to do. And so, do I enjoy exercising the rights protected by the Second Amendment? I do. And I certainly did that evening.
What's it like to fire an AR-15? The only thing I've ever fired is a shotgun.
Yeah, it's certainly a lot less kick than a shotgun. It was interesting how accurate they are, and really how easy they were to handle.
Okay. Well, okay, we're not here to debate how accurate you and I are in the firing range. At the end of the year, you had a sizable fundraising lead over your opponents. How do you raise money for a Supreme Court race, a nonpartisan race, when every giver could pose potential conflicts of interest if they are litigants or attorneys appearing before the court, Your Honor?
Yep. So I think the key to that is bound up in the judicial philosophy that you have. So for me, it's not that hard, because everyone I talk to, I tell them the same thing. Whether I'm talking to a professional organization, whether I'm talking to politically aligned groups, regardless of which side of the aisle the politics might be, whether I'm talking to citizen organizations, I tell them all the same thing. Here I am responsible for applying the Constitution and the laws as written, and I will do that faithfully, whether you like it or not, right, as far as what the outcomes are. And I think the fundraising success that we've had demonstrates that really this is what the people of Wisconsin want. They want justices who are not going to bring their policy decisions and policy positions into the court. They want them to just apply the law. And so when I go around the state and they hear that, they've just been incredibly supportive, and I'm so grateful to them for that.
Have you put any limits on who you would not take donations from, Your Honor?
I've not put any limits on that. At the moment, that's really not come up as an issue.
What is your criteria for recusing from a case, sir?
So yeah, I will recuse from a case based on two considerations. One, if there's an actual conflict of interest, right? So there, I have a personal involvement in the case, or there is some extraneous factor that would limit my ability to appropriately function as a justice, right? So our role is to apply the law without respect to any party or person, and without respect to any outside influence. And so if I don't believe that I can do that, then I would recuse myself. And then second, if there's a situation that creates a reasonable perception of a lack of impartiality if I were to sit on the case, then I'll recuse myself, as I did just recently. So there was a case, there was a petition for bypass that we considered on a case that dealt with voter registrations.
Yes, the so-called movers.
Correct.
Yes.
And I looked at that and I thought, well, I can do the role of a justice on this case. I can apply the law and come to the conclusion that the law requires. However, I looked at that from the perspective of folks in Wisconsin who might be on the outside looking in and seeing what the court's doing. And I thought, well, it would be reasonable for them to say, well, look, this could affect an election in which Justice Kelly is a candidate. And can I be confident that that won't play into his decision on that? And I thought that would be a reasonable concern for them to have. And so I recused myself in that case.
Some groups in the past have said that there should be a financial threshold. If a justice received $5,000, $10,000 from a organization or a company that's a litigant or an attorney, that given if their donations exceeded that threshold, they should automatically get off that case. Your response?
Well, I think that the people of Wisconsin are entirely capable of policing that kind of question. So they've decided that $20,000 is a lawful and appropriate amount for someone to contribute to a campaign. If they thought that was going to adversely affect the justice's ability to do his job, they would lower the cap. So that's a question, that particular question, I leave that to the good judgment of the people of Wisconsin.
In Justice Hagedorn's campaign, a lot was made of his past freedom of speech expressions on social media. Before you were a justice, you made some social media posts on the issue of same-sex marriage and abortion. If a same-sex marriage or abortion case was before the case, and one of the attorneys said, in light of your pre-justice posts, you should get off a case, your response?
Well, I would certainly consider it very carefully. But and I think we need to put that in the larger context, right? So all members of the court, whether it's the Supreme Court, the Court of Appeals, or the circuit courts, all judges and all justices have political beliefs. The question is whether you're going to be willing to set those aside. So before I came to the court, I publicly made known some of my political beliefs. But that doesn't mean I'm any less capable of setting them aside than those who have not expressed them publicly. So I think we all have the same responsibility when it comes to that type of issue. And so I would, if someone asked me to recuse myself, I would certainly look at that seriously. And I would look at those two considerations that I mentioned. Do I have a conflict of interest, or is there good reason for the people of Wisconsin to question whether I'd be able to exercise the authority of a justice impartially in that circumstance? And if I thought that either one of those conditions was satisfied, I would recuse myself.
Justices right now just have to file a statement, I am getting off this case. Should they have to give reasons for that, sir?
I don't think that's necessary. In the latest order, in the first order in which I recused myself from the voter registration case, I simply said that I recused myself. The second one, I thought, well, perhaps some explanation would be appropriate. So my judgment was that giving the people of Wisconsin an explanation for why I'm not sitting on that case would be appropriate, and so I did.
There have been past petitions for what's called a civil Gideon. Someone accused in civil court, accused is the wrong term, someone involved in a civil court action involving child support, maybe even an eviction, should have a right to a court-appointed attorney. Your position on that?
I'm not taking any public position on that, and part of the reason is that's something that could come before the legislature. Frankly, it could come before the court as well. I think that in general terms, I think it's important that when the state focuses its attention on a specific individual to take away any of their rights or liberties, I think it's important for them to have counsel. And whether that's something that should be publicly paid for or not, I think is a good question. And I think that's going to be percolating through the legislature and the courts in the future.
Which state or federal justice do you most admire, Your Honor?
So on the federal level, I would say Justice Gorsuch and Chief Justice John Marshall would be the two I would look to particularly. John Marshall, because he's really he's kind of the father of the way that the courts work today. So until he was on the court, each justice would issue a separate opinion in every case. And then it was for the lawyers to try to go through, try to piece together all the statements from the several justices to figure out what the actual rule of law was. And Chief Justice Marshall changed that up so that there would be one opinion that would be an opinion of the court, and if you can get a majority of the court to join that opinion, that would be the opinion of the court. It made it was revolutionary in the ease and the clarity with which we'd be able to see what the rule of law is. And I think that has been one of my guiding principles in the way that I do my work on the Supreme Court. What we should do, the work that we do should be entirely transparent to the people of Wisconsin. They're responsible for understanding what the law requires of them, and our opinions should be helpful in that regard. So I write my opinions in a way that anyone in Wisconsin, whether you're a lawyer or not, can pick up what I write and understand how we decided the case, why we decided the case, and what the law is that regulates their behavior. And that's one of the reasons that I appreciate Justice Gorsuch so much as well. He's a beautiful writer, just outstanding. And I think he's going to be a great addition to the bench at least for no other reason than that.
You mentioned transparency, yet I think you voted to close administrative conferences. Why?
Because I think that as an administrative matter, when we're not talking about matters that will have public impact, I think it's important that each member of the court be willing to speak frankly, so that we all have the benefit of their unvarnished opinion and thoughts as we make those decisions. And being on the court, both when we had open conferences and closed conferences for administrative matters, I've seen a dramatic difference.
You have?
I have. I mean, whenever as you might imagine, when you're on camera, there are things, you get a little uncomfortable perhaps in what you're willing to say and how you're going to say it.
Right.
When the cameras are not there, and it doesn't have that nervous-making aspect to it. I think that people are more frank, they're more direct, they're more open with what they think, and I've seen that dramatic shift in our administrative conferences, going from kind of a stilted conversation when it was on camera to now when they're closed and we have the benefit of people's full thought and opinion. That's just been extraordinarily helpful.
So the court is working better now that the administrative conferences are closed?
Yes, definitely.
Okay. Just a couple more questions. We're almost out of time. So as you go around the state and you meet a voter in Weston, Wisconsin, hi, I'm Daniel Kelly, Supreme Court judge. What's your elevator speech why she or he should vote for you on February 18th and April 7th?
February 18th and April 7th.
Yeah, elevator speech.
Elevator speech. Thanks for being a great boss. It has been an honor of a lifetime to serve you on the Supreme Court since 2016, taking care that we faithfully apply the text of the Constitution and of your statutes, and making sure that the decisions that we come to are commanded by the law and not influenced by outside considerations, personal politics, or preferences. And if you give me an opportunity to continue doing that for 10 more years, I will keep being faithful to the Constitution and to the authority that you've lent to me. And that's my elevator speech.
Final question. Why are you more qualified, or what are the differences between you and Judge Karofsky and the law professor Ed Falone? Excuse me.
I think that goes back to, frankly, my elevator speech. It's my judicial philosophy. So I have, from long before I came to the court, and certainly since 2016, I've been adamant about the necessity of being faithful to the Constitution and using the authority that we have on loan from the people of Wisconsin the way that they've asked us to, setting aside our personal beliefs and politics and not allowing any of that to come into the work we do as a court. And both of my opponents have been quite open about their commitment to bringing their politics into the courtroom. One says that she is a social justice warrior, and that's her commitment if she is brought to the Supreme Court. Both have campaigned on policy issues such as criminal justice reform, and that's simply not a role for the court to be involved in. In fact, I think it's an illegitimate thing for the court to do. If we do that, if we do what my opponents say that they will do on the court, that's in effect walking over to the other side of the Capitol building, stealing the legislature's authority and bringing it back to the court to exercise there. And what happens if you do that, you erode the entire concept of the rule of law. You cannot have the rule of law if the judges are making policy. Right? We simply have to accept the policy that the legislature has made. And the reason we do that is not out of an undue obeisance to the legislature. It's out of respect for the people of Wisconsin. They've asked their legislatures to make policy, not us.
I appreciate it. Supreme Court Justice Daniel Kelly is seeking a full 10-year term in the April 7th spring election. But there are 3 candidates, so the primary is February, let me get the date, 18th. Do I have that right?
That is correct.
Justice, thank you so much.
Thank you. I appreciate you having me on.
And a programming note, you can see WisconsinEye's interview with Dane County Judge Jill Karofsky, and soon I'll be interviewing the 3rd candidate, Marquette Law Professor Ed Falone. Sir, thank you very much.
Thank you.
Thank you.
This program is a production of WisconsinEye, an independent, nonpartisan, nonprofit media network with a mission to inform, educate, and engage the citizens of Wisconsin. WisconsinEye is the nation's first and only independently funded state civics broadcast network, providing gavel-to-gavel access to government proceedings and events at the state capitol.